Thank you, Alex. And as Alex said, what I want to do in this part of our session is just to consider when one party might be justified in requiring the other party to accept an unlimited liability, and related to that, when a liability which was intended by one party in principle to be unlimited might turn out to be subject to limitations, whether deliberately or inadvertently. The first situation I want to look at is where there's a willful misconduct or a deliberate breach of the contract. In some ways, this might seem an odd starting point to talk about limiting liability in the contract. Can a party in deliberate breach of contract still rely on that contract to limit its liability? But the answer is yes. A party can limit its liability for its own deliberate breach of contract, although the contract needs to be crystal clear that this is the case, because the courts will require some convincing that this is what the parties actually intended. Of course, if one party is dealing on its standard terms, then any such exclusion is going to have to satisfy the reasonableness test that Alex has talked about, and that's going to be a tough call for an exclusion of liability for a deliberate breach of contract. But on the other hand, if the parties have specifically negotiated and clearly agreed the relevant provision, then we know from cases like Swiss Atlantic and Photo Production, which I put on the slide there, that there's no general legal principle which prevents a party from, as it were, avoiding the financial consequences of its own wrong. And the question is simply one of the construction of the exclusion clause. Two cases to note. First is Internet Broadcasting Corporation, known as Net TV, and MAR in 2009, and then a case earlier this year of AstraZeneca and Albemarle, which reached similar conclusions but took different legal approaches. In the Net TV case, MAR gave notice to terminate its contract with Net TV and walked away from the contract in circumstances which it actually accepted in court was a contractually unjustified action. But it then sought to rely on an exclusion clause in the contract to avoid liability for Net TV's loss of profits arising from that wrongful repudiation. The court said that there was a rebuttable presumption that an exclusion clause can't be relied on where there's been a deliberate repudiatory breach of contract. In this case, that presumption was not rebutted because of the literal interpretation of the clause, which excluded liability for loss of profits so that it applied in all circumstances, including circumstance of a deliberate repudiatory breach, would in the court's view create a commercial absurdity. Then in the case of AstraZeneca and Albemarle earlier this year, the court disagreed with the Net TV doctrine of this rebuttable presumption on the basis that there's no need to superimpose this presumption onto the general principle that the courts will both construe an exclusion clause strictly against the party seeking to rely on it, and will also strain against a construction which renders the party's obligations under the contract in effect no more than a statement of intent, and won't reach that conclusion unless no other conclusion is possible. So we can see that in a commercial context, the courts are hostile to a clause that leaves an innocent party with no substantive remedy. And because financial considerations underpin most commercial contracts, it should be carefully considered whether an exclusion clause which seeks to exclude all heads of financial loss will in fact result in the innocent party being left with no meaningful remedy in the event of a breach. A provision that's frequently allied with willful misconduct is gross negligence, but much more care is needed with this expression. Although it's often seen in commercial documents and in clauses such as no limitations in this agreement apply in the case of the willful misconduct or gross negligence of either party. In fact, English contracts law has never accepted gross negligence as a concept distinct from ordinary negligence. The reason for the confusion is probably that there's a distinct concept of gross negligence in the US and also in UK criminal law, which have probably filtered through into the drafting of English law contracts. However, the 2007 case of Tradigrain is clear on this point, where the court cited with approval Mr. Justice Willis in the case of Grill and the General Iron Screw Collier Company from back in 1866. That gross negligence is simply ordinary negligence, but with a vituperative epithet attached. It is possible to argue the contrary view, but if the parties use the expression gross negligence in their contract, then although that expression falls to be interpreted within the context of the contract, as a starting point, the parties must have intended something more than ordinary negligence. And there was support for this view in the case in March this year of Camerata Property and Credit Suisse, which said that, having used the expression in their contract, the parties must have intended to mean something more than ordinary negligence. But the court accepted in that case that the distinction between the two was neither easy to define or even to describe with any precision. So unless the expression is actually defined in the contract, then in my view, referring to it in a liability provision is simply generating uncertainty and making the liability provision harder to apply. And so I would say only accept unlimited liability for gross negligence if you clearly define what that means in your contract. The next situation is where the actions of one party cause the other to incur a liability to a third party. A good illustration is the so-called third-party intellectual property indemnity. This is where one party provides intellectual property to the other party to use, and so that party obtains an indemnity against its use infringing the IP rights of a third party. For example, a software supplier might indemnify its customer in this way. The principle is that the liability of the supplier is unlimited because this is a fault-based liability, and there's no point at which the liability to the third party ought to switch from the supplier to the customer. In theory, it doesn't matter that the liability of the supplier might far outweigh the contract value or even the level of its insurance. This is simply a question of risk allocation. The defaulting party may well be prepared to accept the principle of unlimited liability in this scenario, but that doesn't necessarily translate into writing a blank check. In relation to the third party's claim against the innocent party, the defaulting party may well want to attach a conduct of claims provision. This will set out the procedure to be followed if such a third-party claim arises. Principally, that the innocent party will notify if such a claim arises, will allow the defaulting party to handle any defence of that claim, and won't either admit liability or settle the claim without the defaulting party's consent. Whilst this is usually viewed as a reasonable requirement, the innocent party does need to be aware that this conduct of claims provision represents a series of hurdles that it needs to clear, and that if it falls at any of the hurdles, then it may well not get the benefit of its intended liability cover. Consider, for example, where X is the innocent party and Y the defaulting party. X will notify Y forthwith of any claims which may be made or threatened against him. Forthwith can mean either immediately, for example, terminates forthwith means terminates now, or at least promptly, as in the Arbitration Act use of the word, and it doesn't mean something more leisurely, such as soon as reasonably practicable. Whilst threatened is also a fraught expression. For example, does the first hint of trouble in an email constitute a threatened claim? Or again, X will provide reasonable cooperation and assistance to Y in relation to any claim. What does this entail for X? What level of cooperation or assistance is it reasonable for Y to demand? Equally, in our example, there are concerns from the supplier's point of view, and whilst an unlimited liability in relation to the amount that the customer actually has to pay out to the third party may be acceptable, the supplier won't want to see the so-called third-party indemnity unduly extended to, say, allow the customer to recover all of its internal losses on the same unlimited indemnity basis. And this leads neatly onto the next scenario, which is indemnities generally. In principle, should the party with the benefit of an indemnity expect that the defaulting party's liability under the indemnity should be unlimited? The answer to this is no. There may be cases where a liability under an indemnity may be unlimited, such as the third-party IP indemnity I've just looked at. But this question needs to be answered on a case-by-case basis, and the answer will depend on what the indemnity is for. As a reminder, an indemnity is a promise by one party to reimburse the other in respect of a particular type of liability, should it arise. The purpose is to provide a guaranteed remedy on a pound-for-pound basis for the innocent party, where otherwise the breach of contract may not give rise to such a remedy. But any contractual obligation is capable of being backed up by an indemnity. So, for example, A warrants that the goods are fit for purpose. Could be A warrants that the goods are fit for purpose and will indemnify B accordingly. Leaving aside why A might be giving this indemnity in the first place, one would certainly expect A to strongly resist its liability under this provision being unlimited, simply because there's an associated indemnity. The last point I want to make in relation to indemnities and limitations on liability is the need for careful drafting and consistency between the indemnities and the rest of the contract. Let's look at that example again. A warrants that the goods are fit for purpose and will indemnify B accordingly. And let's assume in the same contract our limitations on liability say neither party will be liable to the other for any loss of profits, and the aggregate liability of each party shall not exceed £1 million. If the goods are not fit for purpose, and as a result B suffers £2 million lost profits, what can B recover? £2 million under the indemnity, £1 million up to the cap, or nothing because of the loss of profits exclusion. The contract drafting needs to make the answer clear, and a failure to join up the drafting between the limitation of liability provision in one part of the contract and a separate indemnity in another part is a common error. Next, insured risks. Should a party accept unlimited liabilities for risks against which it is insured? The answer to this in principle is no. First, because no party will be carrying unlimited insurance against commercial risks, even if its assessment is that in practice the level of its insurance is far in excess of the level of any likely liability. The second reason is perhaps less evident, but it's the principle of an express assumption of risk. Consider the following example. The liability of X is limited to £1 million, or, if higher, the level of X's insurance cover. X is carrying £5 million of insurance cover. What are X's insurers to make of this provision if X notifies them of a claim? If X had no insurance, then X would only be liable for £1 million. But if the insurers accept the claim, then they will have to potentially pay out £5 million. So what insurers frequently do is provide an exclusion under the insurance policy for what they view as voluntarily assumed risks. It's the commercial equivalent of a medical insurance policy excluding the voluntarily assumed risks of taking part in a dangerous sport. And in our example, both parties are at risk. The party with the claim may be working on the assumption that X has £5 million of insurance cover for these liabilities, when in fact it doesn't. And X may find that if the policy exclusion applies, it's not even covered for the £1 million liability. So care is certainly needed when setting liability limits by reference to insurance cover. There can be good reasons for linking liability caps to insurance. In the ICEL and St Albans case, for example, that Alex mentioned, one of the factors the court took into consideration in holding that the liability cap of £100,000 was unreasonably low was that ICL's insurances were at a much higher level of £50 million, and ICL made no attempt to justify the difference. But in the example we just looked at, the parties could have achieved the same result by drafting the contract provided that the liability of X was limited to a particular amount, and that X would hold insurance cover up to that level. The final area I want to touch on briefly is liquidated damages or service credits. We often talk about a contract with a service provider having a service credits regime, by which we mean that the contract has a standalone section dealing with the payments that the service provider will make to the customer if it doesn't achieve the agreed service levels. And one advantage of the service credits regime can be that it's not fault-based and sits separately from the provisions dealing with contract breaches. And service credits are just an example of a form of liquidated damages, a pre-agreement by the parties as to the amount to be paid if a particular failure or similar event arises. One issue to watch out for here, though, is if the service credits or liquidated damages are based on a calculation rather than on a fixed sum. For example, if the goods are not delivered by the delivery date, X will pay to Y an amount equal to 10% of the contract value. Here, X can clearly ascertain the limit on its liability for these liquidated damages, compared to if the goods are not delivered by the delivery date, X will pay to Y an amount equal to 10% of the contract value for each full week of the delay. Here, X has avoided a general damages action by providing for the calculation of a liquidated sum, but there's no actual limit on its liability. So that's a quick canter through some of the potential scenarios for unlimited liability. My two takeaway messages are, first, that there's nothing I've described where liability cannot either be unlimited or excluded or negotiated somewhere in between, subject to what Alex described in relation to the regulatory framework. And second, that clear and precise drafting is always required, not only to address the up to reasonableness test, but also to ensure consistency between the potentially different liability provisions in the contract. And with those thoughts, I'll now hand over to Vanessa and Richard, who are going to look at the two recent important cases in relation to limiting liability. Vanessa.